Good morning, everyone, or afternoon or evening, depending on where you are in this world. My name is Susie Wilson. I am the General Counsel for the Copyright Office, and I am happy to welcome you to our last day, our third day of 1201 hearings. In the section 1201 rulemaking, in case you have wandered into the wrong Zoom room. Before we begin Class 6B, I want to go over just a couple logistical items, which for a number of you will now be very familiar on day 3. My colleagues on the government side will be posing specific questions to the panelists, and we will call on proponents and opponents to respond to those questions. For the panelists, please use the raise hand function in Zoom, and we will call on you. If for some reason your raise hand function is not working, we do recognize the human hand, and we'll get your input. We have a lot of topics to cover, as you may expect. This session is 1 hour, so please we ask that you focus your responses to the questions and keep your comments relatively brief. In addition, today's event is being live streamed and it's being recorded and transcribed by a court reporter. The video and transcript will later be posted on the Copyright Office's website, and we ask that you speak clearly and also keep your audio off when you're not speaking, which helps out our court reporter. Later today, we will be holding an audience participation session. You can still sign up to participate that session using the link in the chat. We just ask that comments during the public participation session be limited. And you can also comment on any of the different classes that we covered this week. So for today's hearing is on Class 6B Video Games Preservation. Before we begin, I would like to invite first my copyright colleagues to introduce themselves. Brandy, can you start us off?
Hi, I'm Brandy Carl, Assistant General Counsel.
Hello, I'm John Riley. Thanks everyone for joining us today.
And hello, my name is Heather Walters. I'm the Ringer Fellow.
And also we are joined today by one of our colleagues at NTIA. Can you please introduce yourself?
Sure. Good morning. I'm Diana Moreno-Hyde. I'm an attorney advisor at NTIA.
Great. So I'm now going to ask the proponents and opponents of this proposed class to introduce themselves. And just to be clear, we did have signups for this. So it's possible on my screen that I'm seeing folks who have actually signed up for the class that comes afterwards. I will not be calling on you to introduce yourself at this time. So when you introduce yourself, please identify the organization that you're representing here. And can we start with the witness appearing on behalf of the Video Game History Foundation?
Hi, my name is Phil Salvador. I am the Library Director of the Video Game History Foundation, and I'm the author of the Survey of the Video Game Reissue Market in the United States report.
Thank you. Can we now have our panelist who is from NYU?
Hello, thank you. I'm Lane Nooney. I'm a computer and video game historian in the Department of Media, Culture, and Communication at New York University.
Thank you. And from, I believe it's Rizomi.
Hi, my name is Dragan Espenschied. I'm the Preservation Director at Rhizome, which is an affiliate organization of the New Museum in New York. And yeah, I've been working with digital art and emulation for like more than a decade.
Thank you very much. And then our panelists who are here on behalf of the Library Copyright Alliance.
Hi, I'm Jonathan Band. I represent the Library Copyright Alliance, which consists of ALA, the American Library Association, and the Association of Research Libraries.
I'm happy to go here. My name is Kendra Albert. I'm an attorney at the Cyber Law Clinic at Harvard and represent the Software Preservation Network in addition to the Library Copyright Alliance.
Thank you very much. Now we're going to turn to those who are here opposing the proposed exemption. Can we start with AACS?
Good morning. My name is Michael Ayers. I'm counsel to Advanced Access Content System Licensing Administrator, normally referred to as AACS LA. We provide content protection technology for Blu-ray discs, including for those drives found in game consoles.
Thank you. And Entertainment Software Association.
Good morning. I'm Steve England, representing the Entertainment Software Association.
DVD CCA?
Good morning. I'm David Taylor, counsel to DVD CCA, and we provide the content protection technology known as CSS for DVDs.
And finally, Joint Creators and Copyright Owners.
Yes, I'm Robert Rothstein for the ESA, the MPA, and the RIAA.
Great, thank you. All right, so to start off our questions today for Class 6B, I would like to turn it over to my colleague, Heather Walters.
Thank you, Susie. Our first question is for the opponents. In reply comments, SPN and LCA amended their Class 6B proposal. The amended proposal would require the Preservation Institution to conduct an individualized human review of requests for access to confirm that the uses will be for the purposes of scholarship, teaching, or research, and the phrase private study would be removed from the exemption test. Could class opponents please provide their views on this proposal? Mr. England?
I think my main reaction to the proposal is that while it is movement, it isn't very much movement in the sense that the preceding 3 years ago, the proponents of this exemption sought to maintain complete discretion over how they would provide remote access to preserved games. And in this proceeding, notwithstanding the changes identified in the reply comments, they're trying to reserve almost complete discretion in how they would provide access to preserved games. And so with respect to human review, that ensures that the process is not fully automated, but nonetheless, it doesn't prevent users from lying or libraries from providing a simple checkbox where users could affirm that they have a purpose of scholarship or research, and a human would note that and allow someone in. Similarly, removing the word primary from the primary purpose test that was in the language originally proposed in this round doesn't exclude the possibility of use of preserved games for recreational play. It just means that the user has a purpose of research, perhaps among other things. So the absence of primary is not the same as solely, and I think the office's analysis would have to take into account the possibility for recreational gameplay. And the exemption still has all the other issues that were noted in our opposition comments, including the permits distribution of copies, or seems to, and does not replicate the experience of accessing preserved games in a library special collection setting in person.
Thank you. Are there any other class opponents who would like to speak on this matter? If not, we can move on to the next question. This is for SPN and LCA. ESA objected to the term private study, which was taken from section 108 and which SPN and LCA have proposed removing from the exemption text here. ESA suggested that allowing private study might be understood as permitting any personal use of the games involved. Do class proponents have comments on how the phrase private study has been understood by preservation institutions in the context of section 108 to date? Nick Albert?
Thank you. Yeah, so as you mentioned, private study comes out of section 108. From our conversations with preservation institutions in the software and video game preservation context, it's, I don't think folks were particularly relying on that that language for providing access. And I think generally we're looking more towards the scholarship teaching and research, which is why we were comfortable removing it. But you know, it was there because that's the language that was historically from 108.
Anyone else? If not, I will hand it over to my colleague, John.
Thank you, Heather. The next question we have is related to the individual review. In the last section 1201 rulemaking, SPN and LCA suggested that if a new rule permitting off-premises access would be a dead letter, if it included complex new technical requirements, but also suggested that novel or complex requirements would be helpful because institutions might not want to tolerate perceived risk. Would engaging in individualized human review of requests for access to confirm that the uses will be for the purpose of scholarship, teaching, or research be that sort of risk that some preservation institutions would be adverse to? If we could get more information on that, that would be great. Thanks, Albert.
Sure. So the reason we suggested the individualized human review standard was to try to strike a compromise between the concerns of the Entertainment Software Association and the sort of need for flexibility that I think, you know, we've emphasized on behalf of preservation institutions. I think in terms of sort of the appetite, you know, the way that the individualized human review relates to the appetite for risks, that's why we talk about it in the context of the special collections model, because, and I'm sure my colleague, Mr. Ban, can speak to as well, this is the kind of judgment call that preservation institutions that are providing access to works do all the time, right? In terms of, you know, works that are fragile, works where it's difficult to provide other forms of access. And so these kinds of assessments are just a normal part of a routine functioning. In fact, actually, a couple of months ago, I myself made a special collections request to a library in California. So we think that this, you know, hopefully addresses some of the Entertainment Software Association's concerns about sort of widespread public access to games, while preserving the flexibility to tailor the specific security measures that are offered to the individual needs of a particular researcher who is accessing it and to the what the institution feels comfortable providing.
Mr. Pan and then Mr. England.
Thanks. So I agree with everything that was said, and it's like the proponents here are sort of bending over backwards to try to meet every possible concern, however far-fetched, that's been raised. You know, we think it's all unnecessary, because again, you know, in all of the history of 1201, there's never been any example of any leakage and so forth. Basically everything that I've ranted about yesterday, you know, we can maybe include by reference in this record, but you know, we're trying to accommodate all of these, you know, concerns that obviously have no real basis. Thank you.
Mr. England.
Several things. First, you know, it's very clear from the record, and I point you to the comments by all of the individual commenters, that the individual commenters are interested in playing games recreationally. So we will all have a careful, lawyerly debate about the fine points of copyright here. But we should never lose sight of the fact that out in the real world, people want access to preserve games to play them for fun. And so thinking about the human review process here, it is at best incomplete. In the 2021 proceeding, the office, for example, identified verification of identity and affiliation as things that would be potentially helpful in preventing recreational gameplay and ensuring that there are serious scholarly uses. But we don't have that in the current proposal, which is a good introduction to my second point here, which is that the proponents' comments talk at various points, and we heard a moment ago that the goal here is to replicate the in-person special collections experience. But the proponents really are sending mixed messages about that. They're not proposing a clear requirement to know that who the users are or why they want to access a game, although they have introduced passingly the concept of human review. And that leads to my third point, where I'd like to respond to Mr. Van's comments a moment ago, that the proponents that are represented here are all representing responsible organizations, and I assume their good faith and desire to provide access under appropriate circumstances. But their comments are full of examples of how the libraries at Ivy League universities would treat preserved games. And it's important to remember that this is not an exemption that will apply only to the universities and Ivy League schools. It potentially applies to any school library or public library, and internet-only organizations like the Internet Archive. And so the office should not and cannot assume that if an exemption is granted with a great deal of leeway for the organizations involved to decide how they want to provide access, that any beneficiary of the exemption would act in the same way as the Yale University Library. You have to assume the lowest common denominator. And I think if any organization under the sun that is a nonprofit, has a library or archive, can put preserved games online, they're likely to be, with few restrictions, we are likely to see a situation with the kind of online arcade that I've been warning against for the last several proceedings.
So I have a couple of follow-up questions to that. I don't know that you're suggesting this, but I want to be clear. If proponents added an affiliation requirement similar to the one that was discussed in the last proceeding, would that just be more movement, or would that get closer to being something that your constituents would support in terms of an exemption?
I don't think there is at the moment any combination of limitations that ESA members would support to provide remote access. So I would characterize that as progress, but not sufficient progress.
And to your comment about the fact that people want to play video games, they want to engage in recreational play, do you think that the individualized human review is not going to be able to prevent that?
I think the point I was trying to make a moment ago was simply that it's not clear what that means. And the proponents who are represented here may well engage in verification of identity and make a serious determination. They talk in their examples about how some school libraries turn down requests to access special collections in person. I think once we open this to every public library, every school library, every internet-only organization that wants to provide access to games, put them up on the website, checkbox affirming the scholarly play, have a person look at it, grant access.
So one other question, people point to the Internet Archive as an example of an online arcade. Would an exemption that had a requirement that the institution has a physical premises and is not online only address that sort of circumstance?
I would say again that it helps, but I believe the Internet Archive has offices, so that maybe there was some way to talk about physical facility in which collections are viewed, but I wouldn't necessarily put a lot of stock in that kind of language, particularly without seeing it.
Next Mr. Ayers, I think you had your hand up next.
Yeah, thank you. At the risk of piling on, I would agree with Mr. England's comments about paying attention to the practical realities that we're seeing here. There are not a lot of individual comments that come into these proceedings, and I think it's notable that the ones that did were in this class, and that a number of them noted essentially the desire to play games recreationally and expressing a preference for games that are in terms of preservation, expressing a preference for the older version of games as opposed to new releases that they felt were inferior, that had very little to do with scholarly research. So I think that's a very important element here that differs from most of the other classes that we deal with, that there is there is some representation from individuals in the public that they're looking at this not in the way that we are. And I would also note that sharing Mr. England's comments, that certainly the folks that are here are representing parties that are going to be responsible, and the fact that they're here is very helpful, that we're all trying to work together to come up with something reasonable. But when something is as vague as human review, I also have to question, is checking the box, identifying the traffic lights and in the picture and checking the box that I'm not a robot, essentially, is that or that I am involved in scholarly research, is that going to take care of it? And frankly, anybody can have a mailing address, and so I'm not sure. When it comes to just checking boxes as opposed to having anything verified, I would have concerns there as well.
I'm sorry, maybe I don't understand the reference to a mailbox.
If there's a physical location where anybody can have a physical location, anybody can open a storefront, anybody can have a mailing address. So to the extent that that might be a mitigating factor in helping to confirm that this is a legitimate resource as opposed to an internet-only workaround, it's not clear that that's actually going to be effective.
In Section 108 is the requirement for a physical premises. It's more than simply an address, though. You have to be making the materials available at that premises. Is that not correct? It's more than a PO box, for example.
Yeah, that's true. Granted, but what does it mean to make them available? I think the broader point is there needs to be a little more substance in that, as opposed to just saying there is a physical location.
Thank you. Ms. Albert, thank you for your patience. You're up next.
Yeah, so I have a more specific point, but I'd like to start by making a more general one, which is we just heard from the Entertainment Software Association that there is literally nothing that preservation institutions can do that would permit the kinds of off-premises access that is required for research. And I think that speaks to the degree to which preservation institutions and the proponents have been willing to make significant compromises, require very specific processes in order to try to prevent the really significant adverse effects that have been caused by these restrictions. That's what we're here with. We did that in our reply comment. And what you heard from Mr. England is that none of that is ever going to be sufficient to reassure the rights holders that it will not cause harm. And I think that speaks to me to the sort of the fact that it sort of tinkering around the edges and being like, okay, we're going to provide these requirements. I think that if we want to talk about what the practical realities are, our reply comments included 2 statements from companies that do regular reissues of video games under licenses, that the types of scholarly access here, and indeed potentially even more broad access of the type that Mr. England has been concerned about with online arcades, does not harm the re-release market. So if we're talking about practical realities, I really want to emphasize the fact that at this point, proponents have repeatedly proposed compromises that allow preservation institutions to provide the kinds of access that is necessary for researchers, while sort of trying to address some of the concerns presented by opponents. It's not clear to me that it will ever be enough to satisfy, right? And I think that moreover, those concerns do not actually appear to be a realistic assessment of the entire field, right? The very folks who are most involved in that the Entertainment Software Association is citing as the examples of the re-release market that is potentially of concern, don't agree with their stance about the potential harm. Finally, I want to sort of come to this point about kind of the public comments. I think that, the idea that, frankly, I find it somewhat upsetting that the fact that people care about these works is being used as a reason to actually make it harder for scholars to access them, right? I think that's a really frustrating and difficult way to treat what is both an art form, but also a cultural product that is incredibly important. And I think harming scholarship and teaching because there might be an interest in recreational play, of which it's unclear that the public commenters actually even understand what the specific exemption at issue is, doesn't feel fair to the scholars and institutions that put a lot of effort into making these works available. I have much more I could say, but I'll stop there.
Thank you. Mr. Salvador.
Thanks. I'd like to respond to the specific hypothetical that was brought up by the Entertainment Software Association about public libraries spinning up these so-called online arcades, or these theoretical irresponsible institutions providing access to games. To continue with this theme of practical realities we've been talking about, building a video game collection is a specialized skill that most libraries do not have the labor to do, or the expertise, or the resources, or even the interest. In terms of libraries that are building meaningful collections of video game materials for research in the United States, I would say it's probably single-digit numbers. There's very few institutions doing that work. That's just for physical collections. When we're talking about remote access, this is an additional layer of building digital infrastructure to provide access to these games that, again, most of these institutions, even the ones building physical collections, do not have. So I'm sure my colleague Dragan can talk more to the infrastructure required to provide remote digital access, but just talking again about the practical reality, there are very few institutions in the US that would be using this exemption. This is really meant for specialized institutions and specialized collections.
Thank you. Mr. Rothstein?
Yes, briefly, I concur with Mr. England and Mr. Rice. I just want to say, though, that there was a comment that off-premises access is required for research. It's really not required, and it's not a TPM problem. It's really a travel problem, an inconvenience problem. So it really doesn't focus on TPMs or depend on TPMs. So requirement, I think, is certainly an overstatement.
Mr. Taylor.
Yes, I'm not sure that it's really very intellectually honest on the part of the proponents to suggest that they're offering all the flexibility here, because when you read their comments, they are not interested in including such limitations as solely. And in the absence of solely, then you absolutely permit the gameplay that the register was very much concerned about in the last recommendation. And as far as the representations by providers of re-release arcades or the likes, I'm not sure that they are really legitimate to the extent that they are not the publishers of these works. So the fact that they are interested and support the exemption, they have a commercial interest to make sure that they have some ability to go look at these works themselves and see how they would work with their own business models. So I would not suggest that their representations are that should be given that much weight.
Mr. Espinci.
Thank you. Yeah, I wanted to pick up on what Mr. Salvador was mentioning. So at Rhizome, we are an online-only organization, actually, and we run a quite sophisticated emulation infrastructure that makes it possible for remote users to access emulated software environments. And yeah, picking up on this, I wanted to say that this is a huge infrastructural effort on our side, which for a very small organization like us, which has maybe in the hundreds of users a month for such a service, it costs us thousands of dollars a month to like keep this going and to maintain it. And so I don't think there is really a risk of like arcades or online arcades springing up everywhere. And also from the experience, how we have been like putting these emulators into public access, I think what was mentioned before about like a sole purpose or a sole purpose, I think there is what we have been doing, for instance, in 2015 already, when there was a discussion about the role of female game makers and female gaming, which was like discussing the roles of like who is doing what and is this even worthwhile being thought of as a game. We were able to enter this discussion by publishing CD-ROM games online from 1995 to 1997, like showing the history. It was the Theresa Duncan CD-ROM, so like showing what kind of history of female game making there is and what like today's game creators can like refer to or build their current practice on. And so, yeah, these are the two comments I wanted to make to what was discussed right now. Thank you.
Thank you, Professor Nooney.
Hi, yes, thank you. I wanted to respond to the characterization that the on-premise site requirement is merely an inconvenience, or as I believe it was referred to, a travel problem. As someone who does this work for a living, it is not merely a travel problem. It is a significant financial and logistical impediment to doing research. I live in New York City. The nearest institution to me that affords in-person access is the Strong Museum of Play in Rochester, New York. That's a 5 to 6 hour drive on a good day, or a flight of several hours. And if I were to, let's say you don't go there just to play a game for a couple of hours, right? Games are a unique temporal medium. They can take 60 to 100 hours of gameplay. They can take far longer than that to acquire mastery at other kinds of games. These sort of impediments, I have been able to work at the Strong twice because of how expensive it is to go there and do extended research. It costs thousands of dollars to put yourself up in accommodation. And I'm a researcher who is fortunate to be at a university that actually funds me to be able to do that. This puts dramatic limitations on the availability of graduate students, scholars employed at universities that do not have extensive research funding, and precarious researchers to be able to do work that, frankly, my colleagues in literary studies or film history have pretty routine and regular access to digitized versions of the kinds of things they study, be it novels, films. The early kinetoscope films of Thomas Edison are available on the Library of Congress website. These impediments do actually are real and significant, and they do impede research, and they impede it in ways that is not equitable compared to my colleagues in other disciplines. Thank you.
And we do also have video games in our catalog. My colleague, Heather, has the next question.
Thank you, John. So this question is for SPN and LCA. Your reply comment stated, this exemption is unlikely to make much difference to anyone other than bona fide researchers who will benefit substantially. Can you define who a bona fide researcher is?
Sure, so
Yes, Ms. Albert.
sorry, I got ahead of myself there.
No worries.
So yeah, so with one of the I would turn if the Copyright Office is curious about this frame, I would suggest taking a look at the original comments where we talk about sort of the special collections practices that are just widely implemented. We interviewed a special collections librarian here at Harvard named John Overholt, who talked about actually the process by which they vet they to do the individualized human review that the exemption requires. So that includes like sort of looking at who the researcher is, what they want access to. It often does not, and I want to be very clear about this, require a specific affiliation, because for all of the reasons Professor Nooney mentions, that has really regressive and problematic effects on the field to say the only people who can access things are folks who already have certain kinds of formal academic institutional affiliations. There are plenty of independent scholars and researchers who put out really meaningful work. But so like bona fide is not like, oh, there's like a checkbox and you'd have to check all of these items, but rather this is the exact kind of review that institutions are used to doing, especially within the context of a particular kind of or a particular request, right? You know, in our initial comments, we talk about Andrew Borman at the Strong Museum talks about saying like, hey, even if somebody is a researcher, you know, they're not going to necessarily give them access to the whole Atari collection, or even, and that they regularly turn down requests for sort of on-premises access by researchers. So I think it's not, you know, it is a standard, not a rule. There's not a set of checkboxes that you can go through, which is why we require individualized human review rather than coming up with a list.
Thank you. So other than people engaging in recreational play, could you provide some examples of who would be excluded from accessing these works?
Sure.
Mix Albert?
Sure. I wanna obey the rules. So you know, I think if somebody was like, hey, I want to access this so I can, you know, take video of the entire thing and put it directly on my YouTube channel, I think that would be the kind of request that that an institution would maybe look askance at. I think if someone said, hey, I want access to this work because I want to be able to, you know, like play it at a party, I guess that's recreational use. But I think, you know, generally speaking, part of the sort of process of looking through individualized review is to screen out requests where the sort of access to the materials is not proportionate to the type of need, in addition to kind of looking at the question of recreational or versus scholarly, you know, teaching, et cetera, uses.
Is there any response from opponents? If not, we can move to the next.
I'll just say that it's clear from Mix Albert's comments a moment ago that the bar here is to be set very low in the judgment of the proponents. That if anyone has any plausible claim to be doing something other than recreational play, and it's consistent with the resource allocation of the preservation organization, access will be granted.
My colleague from NTIA has a quick question.
Sure, thank you. So for the proponents, separate from the limits you're already proposing, you mentioned recreational use is unlikely because preserved games are suboptimal for leisurely play or different from even the re-releases. I believe I have an idea of what you're talking about, but can you expand on this for further clarification?
I'm assuming
yeah.
I should go. So yeah, so happy to talk about this. First of all, oftentimes the kinds of emulation environments that preservation institutions provide access to are just like not, I don't want to say not fun, but not the kind that one might experience if one were sitting at one's TV, you know, sort of playing a game, or even sort of on a gaming computer, right? They're meant to replicate the experience of playing it in an original setting, and they have different affordances, from being able to sort of being able to see different parts of the game, to sort of having implementing loading screen times that are equivalent to the times that would have been implemented at the original part of the game. So sort of just on the sort of sheer emulation functions, right? I think that that's important to know. And my colleague, Mr. Espenscheid, can speak more to the specifics of that if it would be useful to the Copyright Office and to NTIA. On the point about sort of like what games we're talking about, I think that it's important to note that if many as I think the comments from Antstream and Limited Run suggest, as the video game re-release companies, people do routinely buy re-releases of games because they want access on those sort of devices that they play on every day. And that the types of games that are re-released, as Mr. Salvador can speak to, are the ones that are often like financially viable to do so, right? They are often going to be popular, they're going to sell copies. Our comments talk a little bit about Spec Ops: The Line, and there are many other examples, but that's just one that was very much on the top of mind for folks because it was it's no longer available on the commercial marketplace. Where there are lots of games that are of interest to scholars because of their role in video game history, because of their historical importance, that frankly, like, in my personal opinion, which is not what matters, but it's not, that are, let me put that differently, that they're not going to be likely to be accessed for recreational play. I know Professor Nooney's work often focuses on like certain Sierra Online games that are just not actually fun for modern audiences. So there's both a sort of like very straightforward component about kind of how the emulated systems provide access and how that's different from the types of access that recreational players might want. But also sort of the reality of the types of games that folks are often getting from preservation institutions are different than the types of games that might sort of be viable to re-release. I hope that answers the question.
Thank you. And Mr. Salvador?
Actually, have a follow-up to that, if I could jump in for Ms. Albert. Do you see a tension between the concept of preservation and this discussion about emulation and making edits to the game that make it not the same game that was originally published? Can you talk about that at all? Because on one hand, if you are making changes to the game, is that really preserving a work? On the other hand, if you are making changes to the game for research purposes, is that undercutting, I think you talked about this part before, but undercutting the recreational purpose of it?
Thank you for the opportunity. I just want to make sure that I appreciate that question because I want to make sure I'm clear, right? When I'm talking about the types of experiences that emulated access provides, some of them actually may be more true to the original game, right? And that's why they're less fun for recreational play, right? I don't think this is actually about sort of making changes to the game in the way that you're describing tension with preservation. It may involve sort of providing access to particular parts of the game or providing access in particular ways that are sort of more valuable for a researcher, right? If it's valuable to play a specific subcomponent of the game or to access particular files as part of it. And I think Professor Nooney can speak to why that's useful for researchers. I think that isn't at all in tension with preservation. We regularly have preserved works that people look at differently than the original users would have. In fact, that's part of what makes this use fair. So I think I don't necessarily see that tension, but perhaps I'm just not articulating sort of it super well.
We'll see what some other participants think here. I think the order, forgive me if I'm getting this wrong, I think Mr. Salvador is up next.
Right. I'd like to comment more on this this issue we brought up, that perhaps the games that scholarly and research interest exists for are not the same as the ones that are used for recreational play. In our study, we identified this 87% of historical video games that are out of print. And one of the things we emphasize is that the ones that are in print, the 13% that you can access, tend to be ones for which there is some business incentive to re-release. It's games that there is a commercial market for or popular interest for. That other 87%, there's other systemic issues that are perhaps too expensive to justify re-releasing these individual games. A really good example of this to show how there's the distinction between the popular market and what researchers need. We draw a line through video game history in 1985. That's sort of the dividing line from what I think of as being sort of the modern game industry and the older game industry. Pre-1985 games are sort of the silent film of video games. It's these more primitive titles that are still trying to figure out what the rules of this medium are. So they're very useful for historians trying to understand the evolution of video games as a medium. From the sample we took for our research, I think it's less than 3% of games released prior to 1985 are in print, which is significantly lower than games post-1985. And that's an example of these games that are perhaps more primitive or have less popular appeal, but have strong research interest, are not being re-released too often. They are typically not released individually. They're not being sold for $5 a piece. If they're coming out at all, they tend to be in larger compilation sets, but their availability is still significantly lower than these other games that have more popular appeal that are getting commercially re-released. I think that dividing line pre-85, post-85 is a really good example of the difference between what is getting, made available to the popular market versus what is going to be used for research purposes.
Thank you. Professor Nudi.
Yes, I just wanted to speak to both kind of the scholarly uses of games and also the kind of relevance of remakes in this conversation and their usefulness or not to scholarly research. First of all, right, scholars, to underscore what Mr. Salvador was saying, scholars turn to video games often for reasons very different than a recreational user would. I might be interested in in representational issues inside of a game. I might be looking at the way the software relates to the hardware that it was originally designed on. I might be looking at specific audio or color issues that I can only understand in an environment that is trying to emulate the sort of original experience of using it on the hardware that it was actually designed for. And this is what tends to make re-releases actually not useful very often for scholarship. They really do constitute an entirely different kind of game. The IP title might be the same, but playing a game made in 1983 on my iPad is not a comparable scholarly experience. The input mechanisms are different. Games have been sped up and sometimes entirely recoded. You're not dealing with the same kind of integrity of the original historical object, for which, again, if my only way to access that is to travel to an in-person site, then that puts tremendous kind of constraint requirements on my ability to do that work.
Mr. England, I'm going to skip you so we could do all of the proponents first, and then we'll come back to you, okay? Mr. Espenscheid.
Thank you. Yeah, I wanted to come back to this point on how access to an emulator is actually managed online. So and also how that affects recreational use. While it is possible to run, for instance, the simpler games that Mr. Salvador was talking about that were released in the 1980s to for people to download them and to run them on their own computer or in some kind of local setting, because they are so small. They're basically the size of an online ad on the New York Times, in size that you now get with every click. But for more sophisticated games that require different types of operating systems and more complicated software stack, they are run on a cloud computer, and the user is kind of having a Zoom call with that cloud computer. And that also affects how the game reacts to interactions. There is always in that setting, there's always a delay. So it's you can play action games, but they definitely will be a different experience with playing that game, because there's always if you press a button, the signal travels to the cloud computer, the computer reacts to it, and the video and audio comes back to you. So that's really a significant difference, and that also is kind of supporting a more reflected access to such software than being completely immersed in that software.
So can you give me a little bit more information on circumstances where any code or other game materials are copied remotely to a remote user's computer in an emulation context?
Yeah, I mean, I can use the Theresa Duncan CD-ROM example that I mentioned before. So which means like that there's an emulator template and the imaged CD-ROM disk is stored on a cloud computer. And when a user asks for access, that is like there's in that moment, the cloud computer is rented from a public cloud provider. The emulator and the disk is initiated on that computer, and there's an audio video like connection made to that cloud computer. And already like bringing up this computer and copying this data over, this is like how to say, a significant time that people will have to wait for that. And then when they interact with, for instance, they see an object on screen, they click on it. This is a remote action. So that means, and unlike a video, you never know what the next frame is. So these things cannot be buffered beforehand. So there will always be a little delay between the action and the reaction that the users are seeing, because it has to travel through the network.
Right. So I'm not asking specifically about that circumstance where there is something stored on the cloud. I know it wasn't you that mentioned this, but SPN and LCA refer to the creation of temporary copies on a user's computer. Is that common in an emulation context, notwithstanding your other example where materials are stored on the cloud?
I think this is usually not common, because it puts like a burden on the users to understand these legacy systems and to make them run on their own computer. That's like a pretty difficult task. And the service of a memory institution and the curators there should actually be to provide like a better access to these games or any type of software. So that is, from my experience, that is what institutions do, like I don't know, the Yale library or something.
Thank you. Mr. Band.
Yeah, I just wanted to quickly circle back to your question before about, when is preservation, or if you're, shifting formats or shifting storage medium, or, making a somewhat different copy, is it still preservation? And the short answer is that there's trade-offs, and this applies in all different kinds of preservation contexts. I think sort of in a perfect world, if you had unlimited resources, you would do X, but because we live in an imperfect world with limited resources, we have to do Y. And so it's kind of like triage, and you do the best you can, and you try to preserve things. You try to maximize the number of works you're able to provide to preserve with the resources you have, and that involves sometimes making compromises, and maybe perhaps the quality of the preservation copy isn't as good as you otherwise would want, but you don't have unlimited resources to make the highest quality copy that you would make if you had more resources.
I'm going to ask this question because you referred to this, but I'm also aware, because I want to get back to Mr. England. Notwithstanding the Class 6A exemption, can you distinguish the reasoning in Corley and prior Copyright Office exemptions that said fair use does not guarantee access to a copyrighted material in the user's preferred format? So you just referred changing formats. Is this exemption a version of asking the office to bless format shifting?
No, I wouldn't say so. I mean, these are all preservation copies. I mean, we're talking about preservation here. We're not talking about making copies in other contexts. Corley was sort of limited to a very, I mean, that's dicta, that's also limited to a very specific factual context. And here we're talking about a different factual context. I mean, yes, you could. I mean, you could say, well, it's in the preferred format because this would allow a researcher to actually be able to access the work remotely. But I think, for when you're doing the initial circumvention for preservation purposes, and remember the circumvention is already done, right? The work was circumvented in order to preserve it, and now we're simply talking about downstream access to it. And in terms of that, I think that making enabling a scholar to someone like a Professor Nooney to access something remotely so that she's able to access it and perform the research would clearly be a fair use. I mean, that, to the extent that there are any additional copies made, and it would be, completely consistent with under this fact scenario, it would be consistent, not only with the requirements of 1201, but also the requirements of fair use, that this is the kind of, it's not simply the convenience of Professor Nooney, it's to allow Professor Nooney to perform the research, again, because we live in a world with resource constraints, and Professor Nooney can't possibly, travel all over the world with the resources at her disposal.
Right. In the interest of time, I'm gonna ask folks to, the couple questions we have left, to try to be as short as possible, if only for the interest of time. But before that, Mr. England, you've been patient.
Yes, and there's a lot to respond to in the last half dozen speakers here. So first, I think it's important to note that for the last 10 or 15 minutes, we've been talking about cloud-based emulation, and that is consistent with the proponent's written comments, but it's not consistent with the proposed exemption. The proposed regulatory language refers to distribution of copies, and so does not seem to be a exemption that is focused on emulation. So I don't think there is a record that justifies anything other than emulation. I don't think there's a record that justifies an exemption at all. But to the extent the office disagrees, it seems like there is a record on emulation, not other ways of access. Second, concerning emulation, it's a major theme in the written comments and in Mix Albert's comments a moment ago about that emulation isn't fun. But that isn't really what Mix Albert seemed to be saying a few minutes ago. What Mix Albert seemed to say, the emulation is too faithful to the original. But there are audiences for the original games. That's why there's a thriving market for classic games. And so saying that emulation is too faithful to the original is not the same as saying it is not fun. And I think we have some evidence of that. So most importantly, I think in our written comments on page 12, we described some reviews and popular reactions to the cloud-based emulation that's provided by the Internet Archive. And you have people saying things like, it's something to behold, one of my favorite sites. And so clearly there is demand for recreational play of games in an emulation environment. It's not quite on point, but they recently reported some litigation between Nintendo and the maker of a local-based emulator. That was a very popular product. Moving on, Nick Albert referred to the companies that have filed declarations supporting the proponents here, and they're not ESA members. ESA respects their right to have an opinion and the right of any copyright owner to distribute their works through whatever channels they want. I think should note that both of these are, in the grand scheme of things, comparatively niche channels. So I understand that Limited Run is focused on small runs of physical games. I understand that Antstream Arcade is focused on very old games, and so not representative of the full market. Finally, Mr. Salvador mentioned the study, and I think it's just important to recognize that what the study shows is that at a particular moment in time, only a certain percentage of all of the games, no matter how esoteric, have ever been released, were available. And windowing is a well-recognized phenomenon across copyright industries, window of motion pictures, television shows, music, and game companies too have the right as copyright owners to decide how they want to window their works, and shouldn't be forced to compete with third parties that are trying to provide online access to those important intellectual properties.
Looks like Mr. Salvador is next.
Yes, I'd like to respond to Mr. England's criticism of the video game reissue study. This theoretical thing about windowing being the reason that games aren't available. This isn't how the video game reissue market works. The reason that these games are out of print, this 87%, there are a select number for which, yes, this windowing is happening and companies are strategically re-releasing these games at different times. But the reason 87% are out of print is not because of windowing. It's because of these systemic issues we identified in our study, involving the complicated technical issues keeping games out of release, involving significant rights issues for games that are still outstanding that are preventing these from getting back on the market at all. So this isn't a temporary problem. If we're looking at video games as a medium as a whole and not just looking at individual anecdotes, it's systemic factors that are keeping these games out of release, not strategic business decisions. I also want to note that none of the opponents have produced any evidence that disproves what we found in the study. The factors we identified, the statistics we found, this has also been corroborated by these comments from Antstream Arcade and Limited Run Games, who I'll mention often work with large rights holders to reissue their games and encounter these same troubles. Their experiences are valid to this conversation because they're often trying to reissue some of these larger titles owned by larger companies and simply aren't able to because of the issues we identified. That's what's keeping games out of print, not deliberate business strategy.
Salvador?
I know we're at time, so I'll be very brief. I think that I think that just to conclude, I know, you know, this is we have done this many times. We're sort of back here asking again, because the adverse effects on the, you know, people who actually study these games are quite significant. And every time the Entertainment Software Association and you know, opponents say, well, you haven't done, you know, you haven't done it right, you haven't shown the right things, there are these harms, that, you know, first it was games get re-released, and then we have a comprehensive study that says most games never get re-released, and then it's, well, it's going to harm the re-release market anyway, and then we get specific comments from people who are re-release games on the re-release market that actually it will not harm the re-release market. And I think this speaks to what Mr. England said earlier, which is that there is no world in which the Entertainment Software Association is actually comfortable with off-premises access to these games. And so thus, I think focusing on all of these sort of like specific kind of goalpost moving concerns, I think just harms the very scholars who are sort of thinking about researching and training these games and sort of potentially providing that information to future generations. And so I think it's really important, as the Copyright Office considers this exemption and the record in front of it, to just sort of actually, you know, grant the kinds of the uses that are necessary to the institutions that actually have been trying to just preserve these works and make them available to scholars and researchers for a long time. And that is like what we're here to ask y'all to do. And doing so will not harm the interests of the copyright holders. In fact, it may help them it may help them. I'll stop there.
Thank you. I'm going to go to Mr. England, and then we have one more question for this class, although there may be some issues that are discussed in the next class as well that overlap with this class here.
Recognizing that we're already over time, I just feel constrained to respond to Mick Albert's accusation of moving the goalposts. I don't think that the goalposts here have moved at all. We're back here repeating essentially all of the same arguments we had 3 years ago, because the preservation organizations want a great deal of discretion over how they handle very valuable intellectual property, and they have yet to suggest that there is a willingness on their part to do so in a way that might be comforting to the owners of that valuable intellectual property. And so at the moment, there is no set of limitations we would support.
And my colleague, Ms. Walters, has the last question.
Thank you. So this final question is for SPN and LCA. Your comments stated that under the current exemption, if a student needed a screenshot of a game, they would have to travel to a university where the game is being preserved. Can you explain why? And is it your position that you would need an exemption for taking a screenshot? McAlbert?
I will just go. I was about to just go in the interest of time. So no, I mean, it's not our position you would need an exemption in order to take the screenshot. It's our position you would need an exemption to get access to the game to take the screenshot. So if I want to take a screenshot of a particular moment in a particular game, or I, presumably need to play that game to get to that moment, or especially if there is not if not already accessible, which is in some way, which is the case for most games. So I apologize if it sounds like I'm not answering the question fully, but it's not that you need it to take the screenshot. It's that you would need it to get access to the game, which would be required to then take the screenshot.
All right, I think we're going to hand it over for some closing comments to our general counsel. Is our general counsel available?
Yes, thank you so much. And I just want to thank everyone for a really helpful discussion on this subject. And for everyone who is listening online for hanging in there as we went over a little bit. We're going to be taking a short break. We will be reconvening at 12:30 for class 6A. And so hopefully it's enough time for everyone to grab a little caffeine and a little food, and we'll see you again very shortly. Thank you so very much. Bye.